All right, Paul, we're live. Just wait for people to arrive in the room. It looks like we've got 37 people have joined us already, and so that'll start building as more people join the room, and also now the room's active, people will start joining us. For those of you who are already here, my name's Fraser May, and I'm the Communications and Advocacy Manager for Civil Contractors New Zealand. Welcome to our webinar update on the progress of the NZS 3910 contract review. Just waiting at the moment for people to join us in the room, and then we'll get into it. We've got a session that might last about 45 minutes today, and we'll have some time for Q&A at the end of that session. Throughout the webinar, I'd invite you to submit any questions you may have using the chat function. So if you look to the right-hand side of your screen, there are two speech bubbles that say chat under them. So if you click that, you'll be able to ask any questions that you have. And we do encourage you to ask questions. Really important that contractors are up with the play on what's happening in this space, and that you've got the opportunity to engage. So with me today, I've got Paul Buteau, and he is a partner at Dentons, Kensington, Swan, and he's also the legal advisor for the Civil Contractors New Zealand Executive Council. Good afternoon, Paul.
Hi, everyone. Hi, Fraser.
Yeah, and so Paul's going to do the majority of today. Part of the reason for that is because he is one of CCNZ's representatives as part of the 3910 review, along with Jim Juno. So a couple more things, just a bit of housekeeping, I suppose. As I said before, for people that are starting to arrive in the room, please use the chat function on the right-hand side. We can also use that to share relevant links. So you can see there that I've just shared a couple of links to the updates on the revision of NZS 3910 project. And also the recommended special conditions page, which has been released in just earlier this month, actually. So encourage you to check out those links if you haven't already, and I'll do my best to sort of field any queries as they come through. Right, so 2 minutes in, we'll give everyone maybe one more minute to arrive in the room, and then we'll kick on. Obviously, the NZS 3910 review is really important for civil construction in New Zealand. CCNZ has been working hard to get this review to happen, and also to inform it. And yeah, we'll continue to represent contractors on that one. So I think rather than waiting for, we will make a recording of this webinar available following the event. So rather than waiting for more people to arrive in the room, I might just hand over to you, Paul, and let's get going.
Thanks, Fraser. Hi, everyone. I'll quickly take you through what the seminar today is going to cover. In essence, it's going to be in 3 or 4 parts. First of all, just a brief introduction about what the review is all about. Part of that you might have heard before, but I'll quickly go through that. The second part really is going to deal with the interim review itself. They're the special conditions that have just come out earlier this month, and I'll just take you through them. The third part will deal more with the full review that will be undertaken from this point on. That will be released sort of third quarter of next year, and then finally we'll have some questions. I'll work through with Fraser how we'll field the questions, whether we want to do it at the end of each section or whether we'll leave it right to the end, but do put in your questions in the chat function. So today I'll quickly take you through, as shown on the slide, what's happened previously leading up to the interim review, and then there are 4 subgroups that deal with the contract, the indemnity and insurance, engineer payment and disputes, variations, time, technology, and then, as Fraser said, it's really important that we get feedback from you. This is the most used contract in New Zealand. This is the first review for a very long period of time, and it's very important that we get feedback from you on what is coming out, particularly early next year when we see the full review coming through. So just a very, very brief introduction about the 3910 review itself. A completely full review is being undertaken of 3910, and it's a very long time since that last review has been undertaken. In fact, it's well over 20 years since that has occurred. It's happened because, first of all, the 3910 conditions are out of date in a number of regards. Second, we're seeing a huge number of special conditions coming through in some of the contracts that you are entering into, And there is a view that the pendulum from a risk perspective has just gone too far against contractors, and that we need to reset that somewhat. And so a committee has been set up to look at the NZS 3910 contract with representatives from all different sectors: government, local government, principals, contractors, consultants. As Fraser has mentioned, CCNZ has 2 reps, myself as the legal advisor to CCNZ and someone that works with the contract on a daily basis, and Jim Juno is someone that can give sort of on the site pragmatic advice as to how the contract operates and what needs to be changed. We are on various subcommittees, and within CCNZ we've set up 2 subcommittees. One is an in-house lawyers group. We get together and I get feedback from the large contractor clients that have got their own internal lawyers about what they are seeing. And then second, a group represents small, medium and large contractors. I do the in-house group, and Jim Juno and I do the small, medium and large contractors group. We were meant to have a meeting last week. For those that are on the second one, I'm sorry I had COVID, and so that was postponed, but I'll try and set one up for maybe for Wednesday next week to go through that. As I've mentioned, it's been some time since there's been a proper review of 3910. Very quickly, 2013 was the last one. 3910 only had specific amendments that are made. It should be 3910, not 3190. And then there was also the introduction of a design build contract in 3916 and term maintenance, but it wasn't a full review. The last full review was in 2003, and that really focused largely on the Construction Contracts Act. So it's been some time since we've done a proper review of 3910. So the nature of the 3910 review is in 2 parts. First of all, an interim review that deals with non-contentious issues. And because they're non-contentious, there's no opportunity for feedback. Special conditions are released, and I'll go through them with you today. The second, the full review of the entire contract, and it is an extremely full review. I think you'll see that every part of 3910 will be amended, will now be undertaken. It's been ongoing for some time this year, and second, third quarter of next year, released to the marketplace will be the recommended new 3910, and there will be full consultation on that. And it's really important that you review it and have your say. And Fraser will do some seminars through CCNZ, taking you through what's happening with that full review of 3910. Very briefly, the way the committees have been set up internally within Standards New Zealand review is the interim review itself, and I was the representative on that. There's another group that deals with the contract, indemnity and insurance, another one that deals with the engineer, Section 5 obligations of the contractor, payment and disputes. Jim Juno represents you on that. There's time, variations, defects and warranties. That's a big group. Very interested in time and money, because that's what it's all about for contractors. Authorship and technology, how do we use the contract better? And then whilst we've got those various subcommittees, we meet every 2 months, and we have a 2-day meeting every 2 months to go through the whole contract and get an update on that. And then that's the end of the first part. So I want to just get in now to the interim review itself. That's the special conditions that have come out earlier this month, and I'll go through them very quickly with you. But basically they cover 5 areas. To update 3910 to deal with changes in law, primarily within the health and safety area, and dealing with compliance with the law under clause 5.11.10. Secondly, to deal with the core principles and to provide for greater collaboration. Thirdly, and very importantly, to deal with the cap on liability, the indemnity under 7.1, and trying to limit liability that contractors have under that, to make some changes to the law, and then some special conditions regarding insurance. So let's just go through that. First of all, dealing with changes in the law and health and safety. And what I've done is I've replicated for everybody there the change that's been made to the health and safety provision at clause 5.7 of 3910. And you'll see the track change there, which just makes the changes to, in essence, change the 3910 provisions so they comply with the health and safety legislation. The last 3910 was 2013, and just after that came out, there was then a new health and safety piece of legislation that came in, and 3910 has always been out of date with that. So all this is done, and it's fairly minor, and you can see the changes that are made. I won't read them out to you, are to update the 3910 provisions so that it's consistent with the Health and Safety and Employment, Health and Safety at Work Act 2015. And the changes made are just to ensure that consistency takes place. This does not mean that there won't be a further review of the health and safety provisions. That will still be done by the full review committee. All this is doing, but, is ensuring that the health and safety provisions are consistent with the legislation. The next clause just to talk about is the change that's made to the law dealing with changes in the law. And many of you might have been aware that when we had the COVID lockdowns, contractors were wanting to make claims for variations. And one of the grounds that was used were the change in law provisions. And some contractors may have encountered some issues and different interpretations being given by lawyers saying this is how it applies and how it doesn't apply. So a couple of things we've done here. First of all, to update the contract, the 3910 provisions, so that it's more consistent with the legislation. There was a legislation act passed in 2019, which uses different language, doesn't use that word regulation. It uses the word secondary legislation and instruments. And so it was really to try and ensure that the contract and the provisions in clause 5.11 were consistent with the statute, with the Legislation Act, and to ensure that secondary legislation caught things such as audit and councils and gazette notices, where a lot of the COVID changes were made, so that arguments couldn't be raised that there isn't a change in law because 5.11 doesn't cover that. And it's really for that purpose, primarily for those two purposes, updated to make it consistent with legislation and to ensure that claims can be made by contractors under this provision. Advance notification, and this was a bit of a bugbear of mine, it always has been. Previously under 5.20.21.1, which is the early warning clause, advance notification, in 3910, there was only an obligation on the contractor to notify, not on the principal. And that didn't seem right. And so we've updated 3910 so both parties have the obligation to notify the other if there's anything that's going to materially affect the contract price, delay completion of the works, or result in a breach of statutory duty. So it's really to make sure the obligation is on both parties. And then 5.21.2 again has been amended that either party can require the other to meet. Now there's an argument that 521.3, which deals with the consequences of not notifying, is addressed as well. That will likely be looked at as part of the full review. But I think just the change itself to 5.21.1 does now give the contractor the ability to raise certain arguments if the contractor is not warned by the principal in certain situations when the principal was aware of something that would affect the contract price, completion, or a statutory duty. So that's the change that's been made there. And then flicking through, and this is quite a significant area now, the cap on liability. So under 3910, Section 7 is the indemnity section, and under Section 7, there is completely uncapped liability. Okay? That is really important to understand that from a contractor's perspective. If you did not put in a special condition seeking a limit on the liability that you have, your liability was completely uncapped. Now, that created concerns within the marketplace. First of all, it's out of step with international contracts. Those of you that deal with, for example, with a FIDIC contract will be aware that there is a cap on liability there. There's a view that there should have been a cap on liability when the 2013 amendments were made. However, the committee felt that they did not have the authority to do that because it was only a limited review. So nothing happened at that particular time. It's also out of step with market expectations where contractors are saying this is ridiculous. Our liability should be capped. It should be limited. And there is an Advisian report which sort of represents the view that MB and other government bodies, Infrastructure Commission, were putting forward when they did an investigation as to the risk allocation, that a contractor having uncapped liability is of no use to the contract if the contract is insolvent and is liquidated. It just doesn't contribute to a sustainable construction sector. So it's important for everybody that there are some sensible provisions and therefore that liability should be capped. With that in mind, a new clause has been inserted now, a new special condition that provides for a cap on liability. Okay, I haven't replicated the entire clause because it's too long to put onto one slide, but I've summarized it for you as to how it operates. So the cap is at clause 7.2.1 in the specific conditions, and there are three options there. The parties can insert a percentage of the contract price that will be capped, 50%, 20%, 80%, whatever the parties think it should be. There's a default of 100% of the contract price. If it's not inserted, all the parties can just insert a specific amount. But you need to turn your mind to this now when you're looking at your contracts, what liability is going to be capped at what level. There are then exclusions from that cap on liability. And the exclusions, I think we've done pretty well in limiting them because there are a number of exclusions that you might see in the contracts that you enter into. So the exclusions that are made that are not covered by the cap are the intellectual property indemnity, liability to third parties, but you look at backing it off against your public liability insurance, fraudulent, illegal, willful acts. Makes sense that if you've done something intentionally, you shouldn't be able to rely on the cap. If you abandon the contract works, and then if there is some provision at law which requires you to be liable, trying to cap a penalty is something that would be against what the statutes are trying to address. Okay, so those are the only exclusions that have been made in the 3910 special conditions that have come through. That doesn't mean that you might not see still in contracts you enter into principals trying to amend them even further and putting in other exclusions from the cap on liability, but at least it gives contractors the ability to say, this is what the committee, which is representative of the marketplace, principals, contractors, consultants, etc., considers to be a fair and reasonable approach to how the cap on liability should be addressed. So just remember that in the back of your mind if people try and change this by way of special conditions too much. One of the things that there was a lot of debate around was whether or not insurance recoveries should be excluded from the cap on liability. And I was very keen that they weren't excluded because that could very much alter the risk that contractors take on under the cap itself. And I'm pleased to say that there hasn't been an exclusion. You may still see it, as I've said in other conditions, but there isn't one as a standard exclusion from the cap on liability. What it does say, but, and this was following consultation with the insurance industry, is if the contractor is required under the insurance provisions to provide insurance that responds at a level greater than the cap, then the contractor's liability in respect of that loss is up to the level of that insurance policy. That is just to ensure that the insurance responds. That's the reason that's been put in place. The other thing I've got in brackets there is it will also apply to the extent that if the contractor was required to have in place insurance that but didn't, then the contractor will be liable for that breach. Okay. What the interim review does not cover insofar as the liability cap is concerned and the indemnity is concerned is how you deal with consequential losses, indirect losses, loss of profit, loss of revenue, loss of opportunity, those kind of losses. It doesn't deal with that. That does not mean it won't be dealt with. That will be discussed as part of the full 3910 review. It's something that I think we do need to address. Those of you that enter into standard commercial contracts will see an exclusion for consequential losses, and you may already be excluding it under your existing contracts, but the interim review did not deal with that. Similarly, the interim review didn't deal with capping your liability for liquidated damages. Okay, that might be a separate matter that you will need to consider, and that is whether or not you want to cap the exposure you had for liquidated damages with which under the existing NZS 3910 general conditions is uncapped. And a number of contractors, when they look at their liability, say, no, we want to cap our liability to liquidated damages as well. That is something, again, that the full committee will consider, but it hasn't been dealt with as part of this full review. So moving on, the other changes were some minor changes made to the insurance provisions. There is a deletion of the reference to the Forest and Rural Fires Act 1977. That's because that act has been repealed. So again, it's just updating how legislation has been dealt with and I've talked about the changes that have been made around health and safety. That's flowed through also and how it's dealt with under those provisions. Right, so that takes me just to the end of a summary of the interim review. Nothing too scary in there, hopefully nothing too controversial in there, but it is important that you are aware of those changes. It's important that you rely on, particularly around the cap on liability. So do be aware of them. As Fraser has mentioned, they can be downloaded from the standards website. And if you've got any questions on them, please let us know. As I've mentioned, no ability to consult on them because they're meant to be non-contentious. The only comment I'll make before I'll check whether or not there are any particular questions is the intention was actually to look at having a pandemic clause in there and to dealing with how we're going to deal with COVID and other pandemics. Unfortunately, that turned out to be something that was controversial. I can assure you, because I was on that committee, there were a number of arguments between us as to how pandemics should be addressed. It's a risk that neither the contractor or the principal is responsible for. So who bears it? And there were different views between principals and contractor representatives as to who should bear the burden of that risk. There seemed to be general acceptance that contractors should get a time extension, a bit like a force majeure provision, when it's not a default that the contractor has caused, so that there is relief from liquidated damages. But it stopped there. Whether or not the contractor should get money relief through a variation or something less than a variation was highly controversial. And there was a real concern that we couldn't reach an agreement, and that putting something in there that, because it was meant to be non-controversial, was going to be extremely difficult. We got very close, but then we got to a clause that we couldn't all agree upon, and I was certainly of the view that it left the contractor arguably in a worse position because it could be used as a replacement, for example, for 5.11.10 or the suspension provisions, which gives you a full variation right rather than a limited cost relief. It doesn't mean that it won't be addressed as part of the 39104 full review. It will be looked at as part of that, but it will probably be part of a wider review where we look at force majeure provisions and other things such as the war in the Ukraine and generally how other risks under the contract that neither party is responsible for should be addressed, but it is on our radar. So I've talked for a good 20 odd minutes now, Fraser. I might shut up for a bit and see if there's any questions, or if you want me just to continue on and have questions at the end, I'm happy to do that as well.
Well, there are a couple of questions in there. I mean, I guess now that we've covered off a little bit about the interim review, it might pay to first off give you a break, just so everyone knows. Paul's just bounced back from having a bit of a touch of COVID, part of the pandemic there, Paul. Yourself, so good to give your voice a break. But I'm sure we can put some questions in there for you as well. So with the interim review in particular, what form does that guidance take, and where can people access that? So
I think you've got the links already on the chat, and we can email out afterwards how it's going to be dealt with.
So there's the recommended special conditions document.
Yep.
Which is really where these changes in the interim are seen. Is that correct?
Yep.
Okay, and then the second link is to the broader 3910 review page, which has the chair's updates and should give everyone a good idea of the sort of level of discussion and the pace of progress.
Yep.
So
we're quite mindful. So I just mentioned we're quite mindful that we didn't want to release a new document because then you'd have to pay for it, and that just seems stupid when we're looking at what we're really in the context of everything's 2 or 3 pages of special conditions. So we discussed with Standards New Zealand being able to do so in a way that was not going to cost the market to go in there and look at what the changes are and use those special conditions.
Absolutely. And on that note, so the recommended special conditions being available on the standards website, you do have to create a login and then basically agree not to share them unless you've got a business account. So they're kind of, so there's a little bit of detail on how you access those. If you ride through that, you will be able to access the recommended special conditions document at that link. So
Fraser, I can see a couple of other very quick questions, which I'll just deal with.
Go ahead,
first of all, question, will it be mandatory for the latest contract to be used, or can principals still opt to use 2013 or 2003? reality is principals can elect to use whatever they want, and they can amend them however they want. Whether that's acceptable to you or not is a matter of negotiation. But again, as I've mentioned, this is meant to represent the industry standard view on what is fair and reasonable to the parties. So it does give you the ability to argue that. There's a question on whether 3915 is going to be updated. I'm sorry to say that neither 3916, 3917 or 3915 will be updated as part of this review. It's only a review of 3910. Having said that, it won't be that difficult to review 3916 because obviously other than the design provisions in it, it's largely the same as 3910. So I think we might be able to try and keep that going. And then a question on whether or not the 100% would be the maximum percentage for the cap on liability. Answer no. You could very well see somebody seeking a much higher cap than that. Similarly, you could negotiate a much lower cap on that, but at least turn your mind to what the cap should be, looking at a whole variety of factors that will be relevant. The size of the contract, the nature of the risks under the contract, the nature of the parties, your ability to provide a cap. You can have a contract for 50 million to say to somebody, provide 100% cap. Well, there aren't many businesses that could give a $50 million cap and it becomes somewhat meaningless. It could be a contract for $1 million and it could be decided that it's highly risky because of the nature of the works and that the cap should be higher than $1 million. But it's good guidance as to how it's going to be approached.
Yeah, there's one more question about a specific insurance provision. Do you see the insurance provision proposed in 7.2.3 being used as a workaround by principals to achieve a higher cap than that noted in 7.2.1?
It's not really a workaround. It's just a reflection of the fact that the parties did not want to be in a situation whereby you couldn't get recovery from the insurance because the cap on liability placed a limit on what could be recovered.
New question around 3910, the rationale for not updating it. I assume that it could be updated following this review and informed by this review, but any further answer to that, Paul?
Oh, look, I think it's time and money, to be honest with you. I know it's frustrating because 3915 hasn't been amended since 2005. So we're dealing with a document that's 17 years old and very much out of date. But it's going to take a good year and a half to 2 years for the committee just to look at 3910.
And that's in the hundreds of thousands of dollars as well. So
and look, to me it made complete sense to do 3916 at the same time because it's so similar to 3910, and we could have looked at the design provisions. 3917 is similar in a number of regards, but it is a term maintenance contract, so it deals with a period of time rather than a particular piece of project work.
Okay.
The 3915 is quite different, and obviously there's no engineer, there's a principal's representative. It makes absolute sense that it should be reviewed, but we need to get everybody on board with doing that and provide sufficient time for that to occur.
Okay.
So that's quite a nice segue, Fraser, just mindful of time, into the next slide actually, which just explains it only covers 3910, not 3915, not 3916, 3917. There has been discussion in the committee room as to whether or not there should be provisions dealing with ECI, early contractor involvement contracts, a GMP, guaranteed maximum price contract, or a collaborative contract. The simple answer is it's not part of this review. It would be going down a bit of a rabbit hole to try and deal with those matters, ECI contract in particular. And it wasn't thought that the GMP contract was used enough to do that. And this is not intended to be an alliance or collaborative form of contract. It's a contract where there is risk allocation between the contractor and principal in accordance with the terms of the contract, not an alliance form contract where risks are shared to the same extent. So those things will not be addressed as part of this review either. If you think there needs to be that form of contract, give feedback, and through CCNZ, we will see what we can do to push that forward. Just dealing with then the other committees and the full review now that is being undertaken. Probably the most significant issue at the moment, and that's been the subject of the most discussion, has been the role of the engineer. There's a limited amount as to what I can say about this because one of the guiding principles on the committee is what is said in the committee stays in the committee. What happens in Vegas stays in Vegas. So we are limited in what we can say so that there can be full or frank discussion. What I can tell you is that there is a lot of heated debate and a lot of change being looked at with regard to the role of the engineer. It is a significant issue. It is one that has caused a lot of concern in the marketplace. As you'll be aware, engineer has a dual role, expert, advisor, and representative of the principal, but then separately, independently of the parties, fairly and impartially making decisions under 6.2.1. So those are the two roles there. There are real concerns about the engineers not acting fairly, not being independent, allegations of bias, concern as to what role the engineer is actually undertaking when carrying out those functions. Those that went to the National Conference will be aware when I did my session on that 3910, when the engineer is carrying out his or her role, doesn't actually say on what basis, whether the engineer is doing that as the agent of the principal or whether they're acting in that independent certification role. Sometimes it's obvious, sometimes it's not. And one of the things we're looking at a minimum, is making it quite clear what function the engineer is carrying out when undertaking that particular role. So there is a very, very detailed review being undertaken. Again, there's been a lot of reports setting out the concern in the marketplace around the role of the engineer and the engineer's representative. I've talked about some of those concerns around the conflict of interest, around altering of the role through special conditions to remove the duty of care the principal has. If you look at 6.1.1, there's the obligation on the principal. That is often amended in special conditions. The use of public sector employees being the engineer of the contract and what conflicts that creates, the inability of the contractor to comment on who the engineer is going to be or raise concerns with that party. What happens when the engineer is replaced throughout the course of the contract. Contractor is consulted, but that is the limit of it. And the conflict that happens often when you see that the engineer or the engineer's organisations has a dual role. They're meant to act independently and impartially, but often they're involved in the design of the works themselves or some other role under the contract. And then the engineer is asked to opine on an issue which may have an impact on the engineer's functions in a different role, and are they voiding their insurance, and are they able to actually do that? So a whole variety of questions have been raised in the marketplace, including also the qualifications of the people that are engineer and whether they are the appropriate people. So quite a lot happening around the whole role of the engineer, and that is being examined by the committee. And I hope very shortly we're going to come out and give you some further guidance as to where we're going with that. But quite significant changes should be expected there. The engineer's representative, again, we're looking at how that role should be treated. Really, it's the principal's representative, not the engineer's representative. So the language that's used really doesn't properly reflect the role that is being undertaken. There's a review of what powers actually should be delegated to the engineer's representative, and feedback will be sought from you as to how that role could be looked at differently and how that should be approached. Dispute section is also being looked at. This is a real bugbear of mine. I won't be backwards in saying what I think about this. I think the whole of section 13 needs a complete overhaul. It is far too complicated. It's difficult to understand, including for lawyers, let alone the people on site trying to interpret it. It is cumbersome, it's time consuming to work your way through, and it needs to be simplified. So that pretty much sets out my view on that it needs a pretty big overhaul. It is tied in with the role of the engineer and the function that the engineer has, but the process is far too complicated and far too difficult to follow. A classic example of a change I think that needs to be made is under 13.2.4, the request for formal decision. I find it completely ridiculous that the engineer can decide to give a formal decision, despite the fact that neither the principal or the contractor actually seeks one. And that's quite significant because a formal decision has got consequences that flow from that. That includes the requirement then to go to arbitration within a month, unless there is the ability to go to a mediation first, which can prolong it, or a party then has to go through an adjudication process and try and prolong it that way. So that needs to be overhauled and needs to be reviewed, and quite a few changes will be needed to be made to that particular section. Moving on to the next working group, and this is the one that I am on, dealing with time variations, defects, and warranties. Again, quite a big area of this. Quite a few changes have been looked at with regard particularly to the time provisions. That's probably the most controversial area. The variations section will need some tidying up, particularly in the entitlement to a variation. But I think it's fair to say, and I'd love feedback from you, the valuation of variations really is pretty good under 3910 and doesn't need a lot of change to it. I think it works pretty well in practice and most people understand it. The defects provisions are fairly similar. Again, they're pretty well understood and work pretty well. There'll be some tweaks being made there and some tidy ups, but I don't think it needs too much of a change. Warranties, again, changes being made there to differentiate between warranties and guarantees because people get confused as to what applies in each situation, and to the Schedule 13 subcontractor warranty, which really should be a warranty from subcontractors, the principals, and the contractor doesn't need to be mentioned in it. So there are some changes that will be made there, but probably the main focus of that committee has been around the time provisions. And again, you will see a significant amount of amendments being made in special conditions. So we're looking at this clause in quite a lot of detail. What are the grounds for claiming an EOT? Do they need to be amended? How are EOTs notified? And in particular, we are seeing some quite draconian special conditions, which reduces the notification period quite markedly down from, in some instances, 20 working days to 5 working days, and then creates a condition precedent or time bar such that if you don't put your claim in within that period of time, you are barred from bringing a claim. I am very much anti and will be arguing that I don't want time bars in there. I think the mischief they're trying to overcome is quite drastic compared to the consequences they place on contractors and preventing them from bringing claims. So that will be looked at as part of the review, again, to try and address the significant special conditions that are coming in here. The engineer's response, are the time periods for providing that adequate? And how do we deal with the situation where contractors just can't get responses back because there's just continual requests for further information from the engineer and no decision being made? All of these issues were mentioned in the Advisian report and reports from Treasury and MB, and matters that we on the committee are having a look through. A whole lot of other issues regarding time, which are very complicated and which we are working our way through at the moment. Should we deal with concurrent delay when there is a delay by the principal and the contractor? Creates a whole lot of minefield as to what you even mean by concurrent delay, and then what approach you should take as a matter of law. So the committee is looking at that. The standard position that probably most contractors want to seek is at a minimum you should get time relief, so you don't have liquidated damages imposed, and then variations are dealt with basically in being able to prove that you have suffered a loss as a consequence, and so cost relief is far more limited in that situation. Acceleration, the clause for acceleration is often amended in 3910, which entitles the principal or the engineer to accelerate the works without the contractor's consent. The standard general condition requires the consent or agreement of both parties. That is often amended, so how should that clause be looked at? Expedition, where the contractor, where there's going to be a delay to the contract works, but due to an event that doesn't give the contractor an entitlement to time extension, there are clauses that are put in there which aren't in 3910, which requires the contractor to do all sorts of things to expedite the works. How is that going to be addressed? Again, another matter for the committee to look at. And float, who owns the float? A very complicated issue. These are all matters the committee is looking at. And what we will be doing is seeking feedback from you on what you are experiencing and what you are seeing so that we can forward that back to the committee. I've had some meetings with the internal legal group, mentioned the work groups we're on, and also with the small, medium and large contractors to see what they're seeing so we can feedback their comments on that. And I can put forward CCNZ's position as part of the review. Variations. Big bugbear of mine is the ability to omit work from the contractor and then do it yourself. That is quite different to what the general condition provides, and in my view should not be allowed. You have fairly won the work, and unless you are in breach and you don't remedy that breach, and there are other provisions that deal with that, work can be omitted, but it's wrong for the work to be omitted, excuse me, and then for the principal to do it him or herself, or to give it to another party. That is almost tantamount to some form of termination for convenience by the principal. So we're looking at that, and I'm just taking you through already what's happening with regard to the valuation of variations as well. The other issue, just to mention briefly, is deletion of work and how that should be valued. Again, amended quite significantly by the special conditions, and we will be working through that. The reason I'm going through all of this is to let you know that these are really critical issues that come up in your contracts, and we want your feedback on it. And if you've got particular issues that you are facing, or particular clauses or questions, please raise them with us so that we can put forward your position. Very briefly, I'm just mindful that we want to have time for questions at the end, is 3910 is being looked at from an authorship and technology perspective as well. How can we make the document easy to work with? How can we deal with the situation whereby, one, it's easy to understand, so we want plain English. Two, people can use it as part of a modern day tool rather than a document that you can't work on online through computers. And how can we amend it in a way that we're looking at one document with, for example, changes tracked in rather than having documents side by side and trying to figure it through. There's nothing worse when we're reviewing, for example, for our contractor clients, 30 pages of special conditions, and you have to put that next to your general conditions and the specific conditions and figure out how they all work in practice. Really important, I think, that we have an ability to then just track changes into the document itself, so it's really easy to see how the document has changed. And if there are other things that you'd like to see, can you let us know what's going on there? Another bugbear of mine is that changes are made through the specifications, particularly regarding design responsibility that a contractor takes on board, for example. My view is if the contractor is under a 3910 contract and has no design responsibility, but it's going to be amended, put it into the special conditions, don't bury it in the specifications. Okay, so just those kind of issues are really important and matters that we need to just get feedback on. Now, apologies, that's a pretty quick flick through, but it's already 5:15, of what we are doing and the kind of issues that we were addressing through the various committees. What I wanted to do, Fraser, is just use the last 15 minutes that we've got to go through any questions that people have got regarding what we're doing there, provide any feedback, and raise any issues while you've got me online.
Yeah, great. Well, thanks for the overview, Paul. It's really helpful, and it's good to see some good feedback coming through. Yeah, there are some specific questions been raised here. One quite specific one: is there any consideration of adding target cost provisions to the reimbursable option in 3910?
Good question, Dave. There is a the cost reimbursement section in 3910 will be reviewed, and I think as part of that we'll look at whether or not we should consider a target cost type provision. Whether we get there or not, I'm not sure, Dave, but as you'll know, under 3910 you've got lump sum, measure and value and cost reimbursement. Certainly cost reimbursement will be looked at, and we might be able to look at having a target cost provision in there as well. That remains to be seen as to whether we can get agreement. The way the committee works is we are meant to have agreement within the entire committee rather than sort of split views on things. So it's whether we can get that across the line, but it would be good if we could do that. We will be looking at that.
Yeah. So I guess another question is around the representation from Waka Kotahi NZTA in the process. Yes. Something you can say, or is that in Vegas?
Oh look, no, I'm happy. Peter Spees, those of you who may know Peter. Peter is been on a number of major projects. Peter is the Waka Kotahi representative on the 3910 committee. So Waka Kotahi is represented on that committee, and Peter will, who is often engineer of the contract himself, is forwarding through Waka Kotahi's views. Waka Kotahi to date has been pretty good in not having a huge number of special conditions. So it'll be interesting to see what they make of what's going on there.
Yeah, interesting. Just before we go through too many more questions, I think it's really important as well to say, that any feedback, detailed feedback, it's quite hard to ask in the chat function, obviously. So if people do have more targeted long form feedback, please email that through to Paul. His email address is there, and copy in Alan at civilcontractors.co.nz. That's Alan Pollard, the Chief Executive, so that then we can make sure that that's addressed. So just thought I'd say that before we went too much further. Just any more specific questions, though? I mean, there are some on variations in there. Can you see that one, Paul? Do you want me to ask that one?
Happy for you to ask any question. I'll do my best to answer it.
Right. So variations. Current clauses say contractors must carry out a variation if the client and the contractors are unable to agree the variation cost up front.
Yep.
Some clients use it in their favour. Any review of this issue, or is it still a balance that's part of negotiation?
That hasn't been discussed yet, I can say. Even though the contractor can be required to undertake the varied work, it doesn't mean that the contractor isn't entitled to be paid for it. And if there can't be agreement on the valuation of that variation, then the dispute provisions will come in play, and you are entitled to seek relief, and you shouldn't settle for an unfair price if you think that it is completely wrong on that. So I suspect that the standard provision in 3910 will remain as it is, that the principal can require the contractor to undertake varied work. Remember, that's only up to practical completion. It requires the contractor's agreement after practical completion for a variation, but the entitlement to challenge any valuation will remain, and you should be able, and you should continue to rely on that entitlement.
Right, and there was another comment around that as well, around the valuation of variations defaulting to net cost. Any thoughts on that?
Well, I've already mentioned that I think the 3910 provisions dealing with valuation of variations are actually pretty good, and really don't need to be, in my view, at least amended too much. If you've got a schedule of rates, you use it. If there's nothing in the rate that is applicable, but you can derive a rate, then use a derived rate, and otherwise you go to net cost. And there is, I think, adequate provision that if the rate is inapplicable due to the circumstances or nature of the work, then you can work your way through 3910 to get to net cost. So I don't think it's overly broken myself, but I'm very happy if people think it is, to carry through what their concerns are. So if you do have a concern with the way it's working, please do let me know. But there is a route to net cost if you can't do so on a schedule of rates or derived basis, or if you think that those mechanisms are inapplicable given the nature and circumstances of the contract.
Okay. So there's another just question around how to give feedback. So engineer, dual and bias roles, how can we express our thoughts? I think that one's answered on the paper there. If you can just email it through to us to start with, then we can have a look at a detailed breakdown of that. I guess it does hark back to timeframes though, Paul. So if we're talking about the full review, can you give us an idea of, we've got the interim review now, non-contentious, but definitely want feedback on that to start with. In terms of informing the full review, the process for feedback and engagement around that, and consultation, and the timeframes.
Yeah, so look, there are two parts to it. Feedback now, what your concerns are with the contract, because those matters can then be discussed as we're looking at the clauses and drafting what we consider to be the necessary amendments to them. So if you have real concerns now, let us know now. That's point one. Point two is, first, second quarter of next year, the amended 3910 will go out to the market for consultation, and we are expecting a significant amount of feedback from the market. Please have your say. Please either do it directly to the 3910 committee or do it directly to CCNZ, so that the committee can then look at what you have to say about it and review it further based on that. But don't leave it till then if you've got concerns on particular matters now. Feed it through now, because there's nothing that allows me and Jim within the room to be able to say, no, we've discussed this with our members and this is not an acceptable way. It's not market practice. The market won't accept it. It's not fair to our contractor clients. to do it on that basis. And here's some evidence of that and some anecdotes that back that up. So the more you can give us, the better armed we will be to actually argue the issue in your favour.
That's right, and the more work we can do around sort of FAQ sheets and kind of testing that with other people that may or may not be in the same situation. So
yeah, and an example of that, Fraser, sorry to interrupt, but an example of that is certain positions are put forward, and I can just say, look, you can say what you want, but I've tested that with people in my group, and they will just not accept it. That it's just not going to be acceptable to approach it on that basis. It is not fair to put in a cap on. Not fair to put in a time bar on a contractor that they can't pass down, for example, into their subcontractors, because the subcontractor sector will never accept it, or to suppliers. So how are we going to deal with this? We need to look at a different way of approaching it.
So the crux of that really is prepare. Really, everyone should be looking towards how the review is progressing and prepare with the feedback that they have, and make sure that that is in the mix with the review team. I'll put another link up to the review of NZS 30910 project there. There are some very useful chairs reports there, as well as the recommended standard conditions that have been put up on the standards site. So I'll just drop that link back into the chat function now. Right, so what's next, Paul?
Tell me which question you want me to answer.
Yep. So there were a couple there around will better provisions for what constitutes PC be included? For instance, all PSs. So
well, every clause in 3910 is up for review.
Yeah.
So if you've got a concern with the practical completion provisions, let us know. Again, generally, I think they work fine. It's the special conditions that are added to them that create the difficulty.
Right. So, and I guess one of the goals was to have some more consistent special conditions rather than a whole lot of bespoke ones. So we wind up with the recommended ones.
Well, the view is the last thing we want is for a 3910 contract to come out and then to be met the next day by 30 pages of special conditions. Similarly, there is a view expressed, particularly by the internal legal group that I'm involved with, that that we don't just want to put in a special condition because we know it's being made in the marketplace, because that will then become a bit of a default. So it's getting the balance right there. What we are aiming as our mantra is a contract that is fair and reasonable to both parties. And at the moment, there is a real concern that the pendulum has swung too far in favour of principles in the way that it's approached.
Okay. There were some questions there around ending the relationship. So as a client, how to remove an obstructive contract.
Yep.
I guess that cuts both ways.
There are provisions in 3910 under clause 14 which deal with default by the contractor and default by the principal. They will be reviewed as part of the 3910 review. They are commonly amended by special conditions. I understand that depends on what side of the fence you sit on, how well you think they work or don't work, but that will be part of the review that is undertaken, and that might include whether or not there should be termination for convenience, so we can terminate where there is no breach, but that then comes again along with what compensation is paid to the contractor if the works are taken away from them and they're not in default.
Okay, so I guess just to reiterate, we should be looking to engage as much as we can on this. I mean, this contract governs how construction works in New Zealand, basically, and how the terms work between the parties. So, the more feedback we can get to make sure it's fit for purpose and doing the job it's supposed to do, the better.
Yeah. I see Simon's question regarding 9.3.13. I agree with you, Simon. Issue's not just omitting of the work, but it's then how 9.3.13 is amended as to what the contractor is entitled to recover by way of overheads and profit when work submitted. Yeah, that does need to be looked at. It is commonly amended in special conditions. So again, that will be part of the review.
Great. Okay, so I think we've covered off most of the questions in the chat. If anyone wants to ask any specific questions, you can. I can see that someone did put their hand up to speak at one stage. I haven't actually used that functionality on this platform before, but we can give that a go. If you're still with us, there, Sarah. Anyone else, feel free to ask questions using the chat function, and I'll see if we can accept that opportunity to speak there, Sarah, if you're still with us. Oh, it looks like she might have taken off. No, that's fine. Okay, so chat function, anyone else? Last chance to ask any questions. Otherwise, I'm going to have to thank you. Oh, we've got another hand up. Nope. Okay. Otherwise, yeah, thank you for your time, Paul, and all your effort on this one, because I know it's, pretty significant effort for the industry. And everyone on this webinar, thanks for attending. And please email your feedback through to Paul and to Alan at civilcontractors.co.nz. Anything else you'd like to round off on there, Paul?
No, I think people have probably heard enough from me. Sorry, you've had to listen to one person drone on for an hour. But do provide your feedback. I know I sound like a broken record, but this review is significant. It's really important. It's the most used contract in New Zealand. It is really important moving forward that you have a contract that is as fair and reasonable as possible. And the best way that we can represent your views is for you to let us know what your views are. So feel free to email me or Alan or feed through anybody else that's on the Executive Council. Any comments or your own branches, and we will do our best to represent you.
That's great. And from a CCNZ perspective, the broader one, we will also be looking to keep the engagement going on this. But yeah, that's great. So thanks very much for your time, Paul, and for everyone who attended. We'll make a recording of this webinar available as soon as possible. And hope you have a great afternoon. Thank you.
Thanks, everyone.